In this lecture, we will discuss about Indian Forest Act 1927. So, we would like to first discuss the very introduction relating to how it was evolved. So, the first colonial Indian Forest Act of 1865 was enacted by the Britishers to control the entire India's forest land and forest areas. And after that, in 1878, the Britishers they enacted Indian Forest Act of 1878, under which the forest they divided as reserve forest, protected forest, and village forest. So this was the division made by the Britishers while enacting the Indian Forest Act of 1878, and consequently in 1927 Indian Forest Act was enacted with certain relevant objectives and such objectives relating to the quality of water, balancing cultivation and forest, and involving the public and community, then efficient use of forest, then the emphasis on afforestation, then training and educational programs relating to the use of forest and conservation of forest resources, then minimum use of forest and balancing wildlife, nature, and habitat and research technology. So, in brief, we have discussed about the objectives and elaborately the very objectives of the Indian Forest Act 1927 was aimed at to maintain the quality of water in the water bodies like lakes and streams, then to balance the impact of cultivation and other forest activities, and further the objective is to aim for expansion of activities in the forest by sharing of the public and other communities in the forest to take part in activities that help improve the conditions of the forest. Then the next objective that was laid down to inform everyone about the efficient use of forest resources, and the next objective is to ensure high productivity of forest and saving the resources of the forest by afforestation, then to introduce advanced programs that help in increasing the area of forest, then to make the management of the forest better by appointing efficient resource professionals and conducting training and educational programs for them. And the other aim is to ensure long-term harvest levels with the minimum use of the forest resources, and to balance the distribution of wildlife, nature, and habitats, and conserve biological diversity by development and implementation. Then, further objective is to make efficient use of the advanced programs that expand the practice of forestry, than to improve research technologies associated with forest. And further, we would like to discuss about the relation between the Constitution of India with the Indian Forest Act 1927. So, the very importance to forest falls under environment, and that which was inserted into the original document, that is the Constitution of India, under the 42nd Constitutional Amendment Act of 1976, under Article 48A of Direct Principle of State Policy, and under Article 51AG of the fundamental rights, which are directly falling under environment. So under that we found the very provisions relating to conservation and protection of forest and proper and useful way of utilizing the forest resources are being part of the directive principle of state policy to give direction to the state to carry out the provisions under Article 48A of the direct principle of state policy. Further, it is became a fundamental duty of every citizen to preserve and protect the environment, which also includes the wildlife, forest resources, etc. So now we would like to discuss the very provisions of the Act, and as under Section 3, the Act is about the reserve forest. So what exactly the Act expresses, that we would like to briefly discuss the very Act. The Act is Indian Forest Act 1927. The Act contains 86 sections with 13 chapters, and while Section 3 of the Act expresses about reserve forest, it empowered the state government to declare any such area over which it has proprietary rights as object as reserved forest by notification through official gazette. It also empowered the state government to appoint forest settlement officers to determine the right of any person within such area or areas by examining and inquiring any such matter pertaining to reserve forest. In any such inquiry, as provided under Section 4, which provides regarding settlement of rights. So, in particularly, Section 4 provides that after proclamation of any area or areas as reserved forests, a time of 3 months has been given to persons affected and of their right in the process of settlement of reserved forest, and also to decide the nature of right over or in if any compensation claimed by any person. In this process, the settlement officer enjoys the power of a civil court, and in particularly would like to discuss the provisions of Section 10, which relating to shifting cultivation. So Section 10 deals with the practice of shifting cultivation in any area, the claim of any person, and submit it to before the state government. The forest settlement officer may permit or prohibit any such practice of shifting cultivation either wholly or partly, and as per the provisions of Section 11 of the Act relates to the powers of Forest Settlement Officers. So, Section 11 of the Forest Settlement Officers provides the power and may, as per the power, admit or reject any claim relating to the right of way or right of pasture, right for forest produce or to water courses. The state government by official gazette declare any area as reserve forest, and the forest settlement officer is to erect boundary marks and to acquire such land or lands under the Land Acquisition Act of 1894. So, any person obtain of any land of the reserve forest and over the forest produce as per Section 14 of the Act could not alienate such land as it is prohibited under Section 24 of such land as it is prohibited under Section 24. So, any person acquired any right by way of grant, lease, mortgage, or otherwise without the sanction of the state government shall not alienate any such land to anyone. And now we would like to discuss exactly the provisions relating to Section 26, which relate to prohibition of certain activities as per the Indian Forest Act as provided under Section 26 of the Act, the Indian Forest Act 1927, as per the provisions of Section 26, prohibits certain activities inside over any declared reserve forest area or areas, and those are clearing of such forest area for the purpose of cultivation, setting any fire, felling it, cutting trees, damaging tree barks or leaves, dragging any timber, carrying and stone quarries, burning limestone and charcoal, hunting, shooting, fisheries, setting traps, and poisoning water sources. The only exception is that if any right received by any person under any grant or contract from the state government. So also Section 28, which forbids regarding village communities' rights, so it provides about the village communities' right over any such reserve forest. It can be assigned as village forest, and for its management and control, regulations could be made by the state government for all purposes. The state government, as per the provisions of the reserve forest, shall be applied in case of village forest. And as per the provisions of Section 29 and 30 that relates to protected forest. So Section 29 and 30 of the Indian Forest Act 1927 deals with protected forest. Under Section 29, the state government, by publishing notification in the official gazette, may declare any left out area as protected forest or any trees or class of trees of reserve forest as protected forest from a fixed date up to 30 years under such declaration. It prohibited also, as per the provisions of Section 30, such activities like felling, cutting, burning of trees, clearing or cleaning forest area for cultivation, carrying stone quarries, burning of limestone or charcoal, collection of forest produce used as pasture for cattle and any manufacturing processes or for construction of any building. So all these falls under protected areas that is described as per the provisions of section 29 and 30. Now we will discuss about section 32 relating to rule making power of the state government. So section 32 provides the rule making power of the state government to regulate and implement the provisions of the act relating to reserve forest and protected forest, while section 33 provides relating to the penalties and sanctions as per the provisions of section 33 of the Indian Forest Act 1923, which deals with penalty and sanctions for violation and contravention of the rules and provisions of the Act. And as per the provisions under section 35, it is dealing with public interest and the interest in people general. So, section 35 of the Indian Forest Act 1927 expresses that the state government does regulate the reserve and protected forest not as its property but in the larger interest of the public and the people in general. Protection from floods, storms, winds in general, and prevention from landslides and avalanches, and maintenance of water supply in springs, rivers, and lakes, conservation of soil land to check soil erosion, protection of roads, bridges, and railways, and overall the preservation of public health. And while section 39 to 42 which deals with the state duties and duties of central government. So, in particularly, there are certain duties cast upon both the state government and the central government on the matters relating to timber and transit of forest produce under section 39 to 42 of the Indian Forest Act 1927. The central government to fix duties to be levied by the state government on any transporting transactions, import and export of timbers and forest produce either through waterways or on exit through land, to issue passes for such transactions and payment of fees for establishment and regulation of depots which carry on business of timber and forest produce. It prohibits the closing and obstruction of any channel or river banks used for transit of timber or forest produce, prevention and removal of any such obstruction and recovery of the cost. So, explained why the state from such person who is responsible for obstruction or of any negligence in that respect. So, in connection to penalty or offences that we found as per the provisions under the Indian Forest Act 1927, the penalty for offences committed under Section 39, Section 40 and 41. So, any contravention attracts a punishment of 6 months imprisonment and a fine of 5,000 rupees or both in case of subsequent offences of the same nature. The penalty will be doubled. The forest officer is empowered under Section 52 which to seize the any forest produce, the tools, boats, carts and cattle used in connection to offences committed under the Act and produced before a magistrate, or in case of punishable, perishable nature, and may direct the sale of such property. A forest officer or police officer can also arrest any person without a warrant or order from a magistrate against whom reasonable suspicion exists as provided under Section 64 of the Act relating to arrest, and as such under Section 72 we would like to discuss the very provision relating to the search of the premises as per the provisions under Section 72 of the Indian Forest Act. As provided, the premises of the person committing or committed offences under the Act could be such under the provisions of Section 72 of the Indian Forest Act 1927. All such shall be carried away by such warrant issued as per the rules of Code of Criminal Procedure. In short, the forest officer or the police officer must be assisted by the other officials, and during such at least 2 or more respectable inhabitants of the neighborhood must be witnesses to such. Further, a list of these seized items must prepare with signature of witnesses and shall be delivered to such occupant. The report of the seizure shall be used for all purpose as legal documents which could be used for the very purpose of any legal proceedings, and as such we would like to discuss the very provisions relating to the Indian Forest Amendment Act 2019, its very insertions made under the amendment and those drawbacks. So, as per the very insertion, the main objective of the amendment is to give power to the forest officers through equipment and weapons to protect themselves and the forest as well. Under the Criminal Procedure Code 1973, the power of officers is to initiate any kind of such and issue such warrants and take actions on the spot and enter premises of the forest area over their jurisdiction in case of emergency. The forest Officers are even allowed to use firearms and other weapons for self-defense, and the very drawbacks relating to this amendment and provisions lead to we analyze regarding the very drawbacks that we found under the Indian Forest Amendment Act 2019. It has been criticized by many environmental experts, non-governmental organizations and communities living in the forest. According to experts, the Amendment Act can be influenced by any private organizations and forest officers. The main drawback of this Amendment Act was that the forest officers could fire anyone in the name of conservation of forest. This power given by the Amendment Act was very much similar to that of the Arms Act, thus giving such excessive powers to the forest officers could be dangerous since they can misuse it against the people who are uneducated and unaware of the laws and the provisions by adding few land areas as forest land and removing the previous land areas. The livelihood of tribal people living in that area would be affected greatly, and in that connection we would like to discuss one important development that relates to Indian Forest Act 1927, and that is relating to in particularly the scheduled tribes and other traditional forest dwellers. Recognition of forest rights, and those are the important provisions which directly relates to the Act of 2006, that is the scheduled tribes and other traditional forest dwellers, recognition of their forest rights, which this act was enacted in 2006, and in particularly this act has been enacted to recognize and vest the forest rights and occupation of forest land in forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forest for generations. So this act is one of the most relevant, important acts which is also directly connected to the Indian Forest Act 1927, so also to the Forest Conservation Act of 1980. So, to conclude our discussion on the very aspects of Indian Forest Act 1927, no doubt we found various innovative steps and attempts took by the colonial British government by enacting Indian Forest Act 1878 and very wisely dividing the forest lands and forest cover as reserve forest, protected forest and village forest, and no doubt the further enactment of the Indian Forest Act in 1927, which aims at very important objectives such as maintaining the quality of water resources in the forest area and balancing cultivation and forest and involving the public in towards the forest resources and efficient use of forest produce and emphasizing on afforestation, then training and educational programs holding in connection to forest conservation, etc. So these objectives and those provisions relating to the Indian Forest Act, and in particularly appointing of forest settlement officers and prohibition of certain activities and greater emphasis on the rights of the village community over forest land, and in particularly giving emphasis on the penalty for those offences and the very powers given to the forest settlement officers or the police officers and to the forest officials, and the very amendment of the existing Indian Forest Act 1927 in 2019 that we have discussed, in particular the very amendment giving much power to the officials as per the provisions of the criminal procedure code, which we found that almost it is equivalent to the provisions of Arms Act for using the insertions made under the amendment to the Indian Forest Act of 2019, and also how it is connected to the scheduled tribes and other traditional forest dwellers, and in particularly recognition of their rights. And that particular act, which was enacted in 2006, is closely knitted with the rights of the scheduled tribes and other traditional forest dwellers, and in particularly how now it is being legally recognized of their rights in forest land or over the forest land and forest produce and forest areas.